So there's going to be testimony. Excuse me for 1 second. All right. We will go on the record in the matters 24 CF 176, 24 TR 741, and 742. State of Wisconsin versus Rebecca Almandinger. The state appears through District Attorney Kevin Schmidt in person. Ms. Almandinger appears in person with her counsel, Bruce Anderson. We're set today in this matter for a motion hearing. And that is proceeding as such. Is that correct, Mr. Anderson?
It is.
All right. Mr. Schmidt, are you going to proceed first, or are you going to ask Mr. Anderson? I do not see an officer, so I'm not seeing that we need officer testimony.
No, officers aren't relevant to this, and since it's Attorney Anderson's motion and his burden, I think he'd call the first witness.
All right, Mr. Anderson.
I think I disagree with that. It's my motion, I agree. But once the court grants a motion based on my motion, or grants a hearing rather, based upon my motion and the affidavit, I think the burden shifts.
I think Attorney Anderson's referring to State v. Banger, which was overturned in 2022 in State v. Clark, where the Supreme Court of Wisconsin held that the burden shift only occurs if there's a transcript. If there's no transcript, Bentley applies, meaning the burden is on the defendant to prove by clear and convincing evidence that a manifest injustice occurred.
That is true.
All right.
So, Mr. Anderson, please call your first witness. I'm going to presume Ms. Almandinger.
Yes.
Ms. Almandinger, you may come forward, raise your right hand. You're going to be sworn in, and then come have a seat over here at the witness stand.
Do you swear that the testimony you are about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name
Rebecca Joel Almandinger,
and what is your current address?
2353 260th Avenue, Cushing, Wisconsin, 54006.
What is your date of birth?
September 23rd, 1982.
And you were convicted of an operating while intoxicated in Washington County, Minnesota in 2005. Is that correct?
Yes,
And how old were you when that occurred?
23 years old,
Okay.
or 22. I was almost
right.
23.
What is your educational background?
I'm a high school graduate.
Any post-high school?
No.
At any time have you studied law?
No,
Have you ever studied the United States Constitution
no,
or anything about the American legal system?
nope,
Have you studied legal vocabulary?
no.
Now, in this 2005 case in the state of Minnesota, were you represented by a lawyer?
No, I was not.
And when you were found guilty, or any time prior to that, did the judge personally address you about your rights to having a lawyer?
No,
Did you basically get told by a prosecutor what was going to happen?
yeah, for the most part, other than talking to some friends that also weren't legal, didn't have a legal background, that said, just get it over with.
Was that your first offense?
Yeah.
Had you ever been involved in any legal proceedings up to that point in your life?
No,
Okay. If you can, if you recall, do you remember how long that court appearance took?
minutes. It was just, I walked in, I pled guilty, and that was it.
Okay.
you know.
Uh, I believe you might have filled out a form. Do you recall filling out a form?
Yeah, I think there was a form that just stated that I understood that I was pleading guilty to the charges.
Of operating while
Oh.
intoxicated?
Yes.
At any time from the night you got arrested for that case, until you made your final, and perhaps only court appearance. Is that your only court appearance?
I believe so, yes.
Were you ever represented by a lawyer?
No, I
Did
never,
you ever even consult with a lawyer?
no, I didn't.
Okay.
I just have to stop you right. No. Never mind, you can continue. Sorry, I thought I missed something, but I got it now.
Did the judge in that case ask you questions about what you knew about the law?
No,
Did the judge specifically ask you if you wanted a lawyer?
no,
Did the judge ask you or tell you rather? Did the judge tell you that if you needed a lawyer for that case, the court could appoint one or would appoint one for you?
no.
Did you know about the fact that you could have demanded a jury trial?
No, I did not know that.
Did you know that you could, that you were presumed innocent? Or did you think you were, based on what you'd seen in the case, did you say, well, I guess I have to plead guilty?
That's how I felt. I mean, I knew that I was charged with the DWI because of my blood alcohol level at the time. And I just didn't ever even think it was something you could argue against.
Did the court advise you of what the maximum penalties could have been for that offense?
I don't recall if that was talked about. The prosecutor talked to me ahead of time about what, if I pled guilty, what the penalties, they would charge, but I don't know that I knew what the maximums would be.
So the prosecutor was the one who was giving you advice, basically.
Yeah, for the most part.
Okay. Did you actually know what the prosecution, which in this case was the Forest Lake City Attorney, correct?
Yeah.
Did you know what they were going to have to prove to find you guilty?
No.
This prosecutor told you what was going to happen?
Yep.
No further questions.
Mr. Schmidt, questions?
Hi, did you successfully graduate high school at that
Yes.
time you entered your plea?
Yep.
Did you get held back at all?
No.
You got the diploma.
Yes,
Okay. How'd you do in school?
I did well. I didn't have any, I was A/B student.
AB student. Did you do civics classes in high school back then?
What would civics classes talk about? I did a correspondence homeschooling program throughout 9th or 10th, 11th, and 12th grade.
Oh, were
And
you
it-
homeschooled through high school?
Yeah,
Okay. Did you learn about government operation? Like democracy,
yeah, the general,
you know,
what democracy is and stuff.
like the separation of powers in the courts and things like that?
I'm sure that was in there.
Okay. Did you ever watch TV or movies when you were that old?
I'm sure I did.
Okay. So when you were 23, you had never heard that people have a right to an attorney in criminal cases?
It's not that I had never heard that. It was just I had the understanding that the way I was raised, you don't argue against, if you're in trouble for something, you just suck it up. You deal with it. It wasn't a consideration in my mind that I would argue with the police or argue with the court system.
Okay, let me back it up then. That OWI, you probably were arrested, came into contact with an officer at some point, and that led to the complaint in Minnesota, right?
Yep.
What actually happened? What were the facts of your interaction with the police and why they thought you committed an OWI?
Relevance?
And this is from 20 years ago, where she's literally said she doesn't remember some things in her direct testimony. I'm seeing what she remembers about the incident.
Overruled.
I left a bar and grill. I pulled out of the parking lot onto Highway 61, and I was following a friend, and my friend they went through a light. They didn't go through a red light, but they went through the green light, and then the light turned red, and I slammed on my brakes because I didn't want to go through the red light. And there was a package of light bulbs on my passenger seat that went flying and broke. And when I went to try to stop that, I swerved a little bit. And the cop was behind me, and he saw the swerve, and that's what he pulled me over for.
I noticed you didn't mention anything about alcohol at all. Was
I
there any
left a bar,
alcohol?
and yeah, there was alcohol involved. I had been drinking at the bar.
Okay. Was there a blood or breath test?
Yes, there was a
And
breath test.
were you made aware of what the results were prior to you entering a plea?
Objection as to what type of test, whether it was a PBT or a chemical test.
Sustained.
I guess I can get around. I'm asking, do you think you were intoxicated back then?
Yes.
Okay. So part of the reason you entered a guilty plea is you think you were guilty.
Yes.
Okay. So according to the motion your attorney filed, he's essentially saying that something was wrong with your plea colloquy back then. And if that were the case and that were true, you'd be able to withdraw your plea entirely. Why haven't you gone back to Minnesota and withdrawn your plea?
I guess, to be perfectly honest, until you just said that right now, I didn't know that I could go back 20 years and do that.
Okay. She just didn't think of it.
It's not that I didn't think of it. I had no idea that that was an option, to go back and argue something that I already pled to 20 years ago.
Okay. So I'm going to fast forward then to our questions we're asking about the plea colloquy. If you recall, I went on this detour asking about the actual OWI when you referenced the way I was brought up, you own up to what you did, right? So going back to that question then.
Objection to the characterization of her testimony. She said she was raised not to argue with the government.
She also did say that she was intoxicated and thought she was guilty.
Anyways,
Sustained.
oh, sustained.
Sorry, overruled him.
Okay. So I kind of got cut off there. So let me shortcut the question then. Would it be accurate to say then that you did know about the ability to get an attorney, but you just didn't want to because you thought you were guilty and because of your upbringing?
Yes, I would say that's accurate, but also I wasn't aware of what the benefits of having an attorney would have been.
I mean, if you did have an attorney, would you have, given your upbringing, fought the case even though you thought you were guilty?
Well, years later now, from what I understand, had I had an attorney, maybe there would have been different, how do you put?
All right, let's talk about that. What we just saw was a textbook example of how a motion hearing can quietly pack in some pretty interesting moments even if nobody's yelling or throwing anything. This was a motion hearing in the matter of State of Wisconsin v. Rebecca Almandinger, and the courtroom was presided over by Judge Mogen, who handled the proceeding with a steady and procedural hand. From the top, she kept things orderly, made sure everyone had their say, and gave the attorneys room to make their cases. No nonsense, no theatrics, just a well-managed session. Now, let's start with the defendant, Rebecca Almandinger. She appeared in person with her attorney, Bruce Anderson, and honestly, her demeanor came across as sincere and fairly composed. When she testified, you could tell she was nervous at times, but also pretty candid. Her responses were consistent, and she didn't try to embellish or get defensive. She stuck to what she remembered and admitted where her memory got fuzzy. What really stood out was her repeated explanation that back in 2005, when she pled guilty to an OWI in Minnesota, she didn't know she had a right to an attorney, or what that might have meant. And this wasn't just a performance. She described being 22, unfamiliar with the legal system, and essentially being told by a prosecutor how things would go. Her tone and body language made it seem like she genuinely didn't understand her rights at the time. Attorney Bruce Anderson did a solid job walking her through that narrative. His line of questioning was clearly aimed at building a case for manifest injustice under the Bentley standard. He focused on the fact that Almandinger was unrepresented, inexperienced, and not adequately advised of her constitutional rights when she entered her plea. His strategy leaned on painting the 2005 plea as fundamentally flawed not because she wasn't guilty, but because her waiver of rights might not have been knowing or voluntary. District Attorney Kevin Schmidt, on the other hand, was calm but a little sharper in tone. He was firm and tried to poke holes in her narrative without being overly aggressive. One moment that stuck out was when he asked her directly whether she had really never heard of the right to an attorney by the time she was 23. He brought in references to high school civics, television, and movies, anything to show that this wasn't a total mystery to someone growing up in the U.S. He even got a little traction with her admission that, yes, she had heard of the right to an attorney but didn't fully understand the benefits. He did a good job locking that in. And when he asked why she hadn't gone back to Minnesota to withdraw her plea, she genuinely replied that she didn't know it was even possible. That exchange was one of the more human moments in the whole hearing. There weren't any other witnesses or officers in this one, just the attorneys and the defendant, and the atmosphere was respectful throughout. Judge Mogen allowed the attorneys to explore their lines of questioning, but didn't let things get off track. She sustained and overruled where appropriate, without showing any signs of impatience. So yeah, that hearing had a little bit of everything: legal nuance, a quiet but pivotal testimony, and a glimpse into how a small procedural misstep 20 years ago can resurface in a very real way. It wasn't dramatic, but it mattered. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.